offense of outraging the religious feeling of any class of citizens of India by words, either spoken or written, or by signs, or by physical representation or otherwise, insults or attempt to insult the religion or the religious beliefs, which that means rituals, this and that, through speaking and of that class shall be punished with imprisonment of either disciplinary term, which may extend to 3 years or with fine or with both. And another section incorporated in the Zahari is Section 75 of Juvenile Justice Care and Protection Act, Your Lordship. It is written, whoever having the actual charge of or control over a child assaults, abandons, abuses, exposes, or willfully neglects the child, or causes or procures the child to be assaulted, abandoned, abused, exposed, or neglected in a manner likely to cause such child unnecessary mental or physical suffering shall be punishable with imprisonment for which may extend to 3 years or with fine or 1 lakh rupees or both. And they are long, this one, and Section 17, Your Lordship, in Section 7A, and page 14, for next page, Your Lordship. Whoever contravenes any of the provision of this Act or the rules made shall be shall on conviction punishable in the case of first conviction with imprisonment which may extend to 6 months or with fine or with both. A bare provision of Section A in 15, page 15 of the Act of 1954, it is critical to consider an offence under any of the provisions of the said Act or to bring penalty under Section 7A of the said Act. Section 5 of the Drugs and Remedial has to apply, and it has to fulfill the definition mentioned in Section 2 and Section 2 of the said Act, which states as follows: advertisement includes any notice, circular, label, wrapper, or other document, and any announcement made orally or by any means of producing or transmitting light, sound, or smoke, or magic remedy, includes a talisman, mantra, kavacha, and any other charm of any kind which is alleged to procure miraculous powers or in the diagnosis, cure, mitigation, treatment, or prevention of any inhuman or animals, or for affecting or influence in the structure or organic function of body of human beings or animal. For example, if a person is blind, through this magic remedy, the structure is changed by so that he can see, like that. So this allegation is there, section has incorporated, which doesn't correspond to the contents of the nature of it.
Is it still under investigation? Is it still under investigation?
Yes, Your Lordship, but I have to rush because the council where I'm appointed, they know these sections because they're human rights people. They know it, they pointed out, we appointed you for this purpose, but what is happening like this? This is a serious allegation like this. So I have to rush before this Honorable Court for Justice because it doesn't correspond.
Only after going through the case diary, it can be possible actually how these case persons are involved in committing. Without case diary, it would be difficult.
1995 is affected or
Yes,
not, but there are some allegations of I'm inappropriately touching the
Yes,
child and all that.
Yes.
While allowing
By that time, most probably POCSO may be also added.
Yes.
I don't know, but maybe it has to be paid.
Yes.
While allowing absolute bail, the learned session charge after perusing the CD, page number 31, Your Lordship.
It's okay. Bail is
Already under protection.
You are already under bail.
Allegation made in the are of generalized nature.
You are already on bail. Should list one. Fix any date for
On 27/8.
27/8.
27/8.
Let it be on 28.
28.
Oblige.
Lordship, I came for after some time, Lordship. Oblige, Lordship.
May it please, Lordship. Lordship, the case is under Section 303 BNS and Cattle Preservation Act 11D 1D. So, Lordship, I am the
303. What is it? 303.
303 theft.
step. Lordship, I am the owner of the vehicle and I don't have the information about the transportation of illegal carrying the cattle. And my vehicle is given on rail to the cattle owners. And so I don't have the information regarding the transportation of cattle. And and my name is not mentioned in the FIR also. So, I may kindly be given the interim protection, Your Honor, Your Lordship.
There was 25 numbers of cattle were carrying and the legs and mouth of the cattle were bound with rope. So, Pamela Pessimel offense under.
I am not FIR.
So, without the knowledge of the owner, my lord, only schedule in it.
It was given friend to the other person. The first had vehicle on train and he has no knowledge about the carriage or transportation of the cattle. However, he is very high burden case that will be Mr. Bott that being the owner of which he he is aware about the transport the cats were transported with according to the output. Okay, you will be under interim protection after before the IU 2017. What for any date?
My lord, on 28 minutes. 20.
Lordship, I will within 10 days.
Within 70.
Deploy.
Maybe lost you. Case 79-406, my lord. Allegation page 12. The allegation is that my lord, that some Bagme Shubhag is suspected to be Shubhag might have found in the house of the present petitioner. Subsequently, it was given Jimma to some other person, my lord. And that person sold those Shubhag, my lord. This is the case. That allegation is not against me, madam. That person sold in conspiracy in consultation with us. This is the allegation. Page 12, we are also kindness. And no 41 notice, nothing is there, madam. Simply 2 persons already arrested. And this is a scope pre-arrest bail, madam. Page 12, we are also kindness. Jimma lo ise mane jone nije ahi. From third paragraph, your lordship basically says. Third paragraph, last my lord. and the risk of damage, there is no space in the police station. So one Abdul Sabur volunteered to assume the responsibility for the Shaykh Supari until further orders and until results. Regrettably, it has come to know that the aforesaid so have been illegally sold by the Abdul Sabur. So along with the present petition, this is the matter that we have. And 406 379 matter, notice must. My prayer is matter your lordship may call for a Syria in the meantime, your lordship can see a protection matter. His father and brother already arrested.
Here only difficulty is that police initially find those 250 bags of supari in the residence of the present petitioner.
Yes.
Thereafter, without intimating police, while police already seized those Burmese suparis, within that period, he along with other person already sold
Not
them.
he.
So the present
Abdul
petitioner.
Sabur.
Yes,
Another person volunteered to take responsibility.
along with
of them.
Shafiqul Islam, one
That
of the
is- that
super
is
his
that.
father, and without prior intimation to the authorities, they sold it to someone other.
So main allegation is Abdul Sabur. And that is not Bagme suspected, that was not ascertained also, my lord. Your lordship will find from the FIR itself, my lord. To ascertain, third paragraph, my lord, whether it is Bagme duly collected for testing to ascertain the origin of the suspected Bagme. Third paragraph, middle portion, my lord. Page 40. During that intermediate period, my lord, this thing happened, my lord. And everything is now,
Abdul, it was under custody of Abdul.
yes, yes.
Abdul Subur along with Shafiqul Islam, owner of the supari.
No, that
They
is,
sold it.
I was not present even now. FIR sold this. And this person, my lord, your lordship, next page, father and brother already arrested.
Let him record his statement.
Yes.
379 and 406 may be arrested.
Yes.
Against them, 379 who are getting 50 back. Because also one Muda
It is within their knowledge that regarding that supari police investigation is going on. So during investigation, they sold these suparis to someone other man. Otherwise, my lord, this is serious offense.
Yeah.
During police investigation
My lord,
of
it
those
is
seized
involved
suparis.
somebody else. How it is? Any matter, he will appear in statement, my recorded, madam. My learned friend is also.
Otherwise, I am not about Burmese
along with
supari,
one Sopur sold.
because
Yeah.
if he is only the owners of the Burmese supari, that is a my lord,
No, not Bagme,
But-
not yet
yes.
certain.
those suparis. But during police investigation, while police says those suparis, during that period, my lord, you sold it to someone other. My lord. That is the difficulty. Anyway, my lord, let him record his statement.
Yes, but he will appear, his statement will be recorded.
MHO.
That's so good to you due to know people. But he could have arrested already arrested.
One going up what take possible but while at first comma then other allocate one other 4 people but someone else and don't keep it priority according the one record he just bought a good name.
On my lord, 21/8.
He will be under FPR protection. FPR, yeah.
Obliged.
May I please, Lordship? It's a second bail application. Yeah,
It's a second.
second
Earlier
application.
rejected. Updated
Though it
president.
is second bail application, Lordship. Kindly have a look the order, page number 12,
His number?
second
Twelve.
paragraph. Second paragraph. Sufficient material against the accusation in the name of loan the petitioner used to threaten some person if they could not return the money, used to take higher amount in the name of interest, even used to take PAN card, Aadhaar card from the person, used to withdraw their money from the provident fund. Lordship, by PAN card and Aadhaar card of others, no one can withdraw any from others' provident fund money. It's a fact. And to attract section 384, there need to be delivery of property.
Okay.
The very essence of the ingredients, delivery of property must have been happened. But in this FIR, there is only a pretension part that the petitioner used to treat the informant from her provident fund. When she had refused return, she had not returned the principal amount. The interest, whatever has been taken by the petitioner, he legally not permissible because at that time he has no money lending certificate. So if someone can take interest in the name of giving loan, it's a bailable offense. Money lending.
In subsequent bail application, we are calling for the case back. Updated that report. I guess
From on my lord, 12/8.
No, sir, the petitioner is ready to go for it. Can we protect?
the second and subsequent bail application on
Subsequent.
the of the case diary, the order has been passed. Let us see the case diary.
All right.
Over here.
Please, Your Lordship. Lordship, the matter may be passed over for time being. Lordship, my senior is on lags in court number 4.
NCB লাগে ন ইয়াতে NCB is there. None appears on both for both the petition list according to after one week.
May it please, Your Lordship. This is the 439 of the CRPC, and the accused person was arrested on 15/6/2021. He is in custody more than 3 years already. And Your Lordship, this is the search matter, and the search has been framed on this case on 11/11/2021. Since that day, taken the more several times by the trial court for the evidence, but only 2 witnesses has been cross-examined out of 7 witnesses, Your Lordship. And there have a delay of trial, and Your Lordship, the IO has failed to appear before this court after directed by the honorable trial court for personal appearance, Your Lordship. And I have annexed in this order on page number 30 to 33, Your Lordship.
Here, Lordship, on the last occasion, Lordship, by order dated 24/6, Lordship, updated records were called for, Lordship. The office note 27, Lordship, is completed. It has not
But
been
he is in
received.
custody more than 3 years, Your Lordship. And here have been several judgment which is passed by this honorable court that Your Lordship grant of the bail on the ground of undue delay in the trial cannot be said to be fettered by Section 37 of the NDPS Act 1985 inasmuch as Section 436A of the CRPC is made applicable to the offences under the NDPS
As
Act.
per her submission, most probably in earlier occasion, on its order passed on.
Kindly may allow for submit.
4/5/2024, one order was there,
Yes.
wherein it is there that the 4 PWs has been examined.
Okay.
Therefore, it is clear as to whether, and it's not clear as to whether 2
No, Lordship.
PWs examined on
2 witnesses
PW4.
cross-examined. Already I have submitted the correction copy, Your Lordship.
PW4 is actually PW2, Lordship. It was
Yes,
wrongly
PW2.
stated as
Right.
PW4.
2 PWs examined.
Yes, Lordship. This is the corrected copy. And last witnesses is the 19/4/2000.
It is
No, it's okay. It's okay.
now, Lordship.
So now, what kind of up-to-date you're required now?
Lordship will kindly come to order dated 24/6, Lordship.
No witnesses come, Your Lordship. I am the advocate of the trial
26.
court.
Yes, 24/6.
Yes.
Lordship. Updated records were called for, Lordship. And office note 27, Lordship, it is stated that not received.
So now your scan copy is of
His Lordship, before Lordship 24/6, in his scan copy, Lordship, the last date was fixed on 3/7/24.
37.
3/7, Lordship. So what?
22.
No, 24, Lordship.
Then it's almost updated, I think. Next.
Yes, Lordship. No witnesses come, Your Lordship. I am the advocate of the trial court. I was waiting since morning to evening, Your Lordship. No witnesses come, Your Lordship. And already he is in custody more than 3 years. Several time has been taken in this case, Your Lordship. Without any reason, Your Lordship.
It is not PW4 but PW1. 2.
2 years, Lordship.
Subhash Singh.
Subhash Singh, yes. Last Subhash Singh, and he was come and appeared before this court on 19/4/2024.
Just we need to know whether on 3/7 is there any
Yes.
witness evidence. He submitted
No.
that no witnesses have been
No,
examined.
Then
In that case, do you want to
We
get
can-
it any escape copy?
We can proceed, Lordship, if he is submitting, Lordship, that evidence is not been taken on this date.
Do you have the case status report of 3/7/2024? Do you have any case status?
3/7, I have no any case status report, but Your Lordship, I have taken several time in this case, Your Lordship. Kindly my request before this honorable.
No. I'm not on that. I'm just saying that. Do you have any case status report of 3/7?
No.
You can obtain it, I think.
3/7/24, I have given the Hajira, Your Lordship. But no witnesses come on that day. I was
For her
appeared before
submission, no witnesses turned up.
no witnesses come. And the last witnesses is come on 19/4/2024. And search frame on 11/11/2021. Since that date, only 2 witnesses cross-examined. It is the delay of trial, Your Lordship. For this ground, I have filed this bail petition for granted bail to the accused person, Your Lordship. For the production.
Date.
Yes, yes, and it's recorded your submission or with the submission. So as per you, he is in custody since
More than
when?
3 years, Your Lordship.
How more than 3 years?
15/6/2021 arrested date.
Date of arrest?
15/6/2021.
21.
Charges were framed on 11/11/2021.
Yes, sir.
CS on? CS on where?
Yes,
On the year of 2021, your lordship. Yes, also. And charge has been framed also 2021. 11/11/11. After arresting 3 months, charge is submitted by the police.
Charge sheet is 10/9/2021.
10/9/2021.
10/9/2021.
Yes, lordship. Page number 19. Annex 4.
As per the charge sheet, lordship, there are 7 witnesses. 2 have been examined.
Any other submission from your side?
Yes, lordship. Because the petitioner is in custody since more than 3 years, and the charge has been framed on 11/11/2021, and since that day, only 2 witnesses cross-examined. So this is the undue delay of the trial, your lordship. So bail may be allowed, your lordship, in any condition.
Judgment.
Yes, they have also judgment also. I may allow to submit it. Ravi Prakash, yes. This is the Supreme Court judgment recently. And this is the BA number 3459/23. Paragraph number 7. BA number 3487/23. I have also mentioned on paragraph number 7. All are the commercial quantity and granted bail on the ground the delay of the trial.
Okay.
Here, lordship. I think that's just sufficient, lordship.
Yes.
Here, lordship, as she has pointed out, lordship, the IO was directed to appear on person, lordship, for the trial court, lordship. So,
He has
And-
failed to appear.
yes, he has failed to appear. And, lordship, in case 44 also, she has annexed the order dated 14/2/23, lordship. There it is stated that the trial court has taken every possible step to summon the witnesses, lordship. But it is seen, lordship, that it is no prosecution witnesses have appeared till date. Summon to witnesses issued white number so and so returned unserved with the report that the PWs have been transferred outside of GRPS Guwahati, lordship. So that is one aspect. Secondly, lordship, trial court is doing its best to called the witnesses, Lordship, to expedite the trial. And the IO has also been summoned to be personally appear, Lordship. Now, Lordship, as regards the judgment that has been cited by the petitioner, Lordship, in the Ravi Prakash judgment, Lordship, there was a total of 19 witnesses, Lordship. One was examined, Lordship, only. And there was he was in trial, in custody for 3.5 years, Lordship. Here, Lordship, out of 7, 2 have already been examined, Lordship. And in the next order, Lordship, of the coordinate bench that has been furnished to your Lordship, there, Lordship, no witnesses were examined, Lordship. So, this case is on a different footing, Lordship. The trial court is doing its best to expedite the trial. 2 witnesses have already been examined, Lordship.
But only 2 witnesses, Your Lordship. We have 5
Only 2
witnesses
witnesses
here.
out of 7, Lordship.
Yes,
It is not
Lordship.
that there are 14 or 15 witnesses, Lordship. So, and a direction can at best be given to the trial court, Lordship, to
No,
expedite the trial.
Lordship. The petitioner is in custody, Lordship, more than 3 years, Your Lordship. There have been many cases which they granted bail by this honorable court, Your Lordship, in a commercial quantity. And I have failed to appearance, Your Lordship, which is I have annexed in this petition, Your Lordship, on page number 30 to 34, on dated 10/4/2023. Since not come, 2024 is here, Your Lordship.
Oh, yes.
Lordship, any condition, Lordship, may be allowed, Your Lordship.
Okay, pass the order.
Much obliged.
My Lord, I am extremely sorry, my Lord. In item number 7, I could not appear, my Lord. My Lord, passed an order list after 1 week. My Lord, it will be on Friday, my Lord, on 6/26.
I cannot say. Upon other hand.
May I please, Your Lordship?
Lordship, kindly talks about a matter for time being, Lordship.
My Lord, last time Your Lordship was very.
Yes, I can understand for the time being. It is where is the senior?
My senior is a late in court number 24, Lordship.
My humble submission, Your Lordship, fix the time at 12 or 2.
She is with the best part. Yes. Where it can be fixed.
At 2, Lordship.
At 2.
Yes, ma'am.
And there are. You were fixing at 2.
Yes, ma'am. At 2, his senior will not fail, ma'am. That is important, ma'am.
Highly obliged.
Lordship, matter may pass over for time being.
Time being, you say it may reach, may not reach, huh? I don't know. Okay, we're passing it up for time being because there are similar matters are lots of matters. All
Lordship, engaged senior counsel is out of in
Out
court
of
number 10.
session.
No, court number 10, Lordship.
it's suited if time permits. Oh, yes. Bar after bar. Right. Item number 20. Affidavit. We have received your affidavit, but the petitioner is not here.
May I please, Your Lordship?
They have filed their affidavit.
Yeah. Lordship,
Have you
till now,
received
4
the copy?
PWs has been examined.
Have you received a copy?
Yeah, I have received the copy. Lordship, 4 PWs has been examined, and we want to, in the trial court, we want to bring that on record. So we will file one affidavit. 1 week of time may be granted.
So, but your affidavit got said. You are for the response number 2. So as per you, how many witnesses?
4 are done. So we
Four
will,
witnesses
yeah, 4
were-
witnesses done. So we will bring that on affidavit record.
You are Mr.
Visit Mena.
Pardon, sir. Amen. Yeah. Your P. Khatunia.
N.
M.
N. Verma.
Pardon. Or that not Mr. Sharma, particular number 1. MS Verma has got this one defined in a position for number. Mr. K. Menon, that and expert that more about and petitioner was the record record by the and recording. When can you be able to find?
Next week. Let it come on August.
Yes, it's in August.
August.
August 12th of August.
Yeah, please. Well, I am appealing to item number 23, man. Lordship, here, my lord, this petitioner, he was arrested on 22/4/2024, my lord, and the contraband plus the 20 numbers of codeine cough syrup been recovered, along with some suspected heroin, my lord, brown sugar. And my lord, I was arrested only on the basis of the statement of the two co-accused, my lord. Forwarding report as well as, my lord, Lordship kindly take up the page 44, my lord. The rejection of my bail by the trial court, my lord, page 44. Point number 5, my lord. But I have perused the case diary available before me. As far as the manner in which the accused was arrested from the court premises is concerned, nothing could be found from the case diary that he was arrested with a malified intention by police. There is no bar from arresting a person from the court premises. He was arrested as he is suspected to be involved in another case. I have also perused the statement of the other co-accused as well as the statement of the present accused person recorded under 161 CRPC. Both the co-accused have categorically implicated the present accused in the illegal trafficking of drugs, madam. That's all, madam. Which is not admissible as per the new judgment, madam. The Tufan Singh's judgment, madam, the Supreme Court has categorically stated that cannot be taken into account, even in the bail application also. And nothing was seized from me, only from the co-accused it was seized, and the allegation is that the co-accused was already been apprehended. They made a statement against me. Apart from there is no material, madam. So as per the Tufan Singh's judgment, my lord, in 439, my lord, the co-accused statement or the statement implicating himself, that cannot be taken into account, my lord. That, lordship, Tufan Singh judgment, my lord, 2021, 4 SCC, my lord. Paragraph. 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 मंदिर बोली है पैराग्राफ मिलवा के हैं इस पर वही सुनिए so probably there is no other material to implicate me in this case my lord in the case that I don't know what is the material my lord if there is no other material my lord I am entitled for bail as far as the Tufan Singh is concerned because I have other allegations also my lord that there's some dispute with the officer in charge of that particular police station and he has implicated me in other case when I was granted bail by this Honorable High Court. There is some observation against him. So that is one of my point. But whatever we make, well, the legal point is that if I am otherwise not involved, there is no material, then I am entitled for bail. If the only material is the co-accused statement, my lord.
My lord, yes, my lord, initially, my lord, yes, from the position of the present petitioner, my lord, here item number, this is item number 23, my lord. Here there are two items, item number 22 and 23, my lord. 23 is the present petitioner, my lord, from whose possession, my lord, no, those contrabands were not at all recovered. Those contrabands were recovered from one Anwar Ali and the present petitioner, item number 3, Hassem Ali Paramani. Those are of commercial quantity. And now the still investigation is going on. Till now, my lord, what are other materials, my lord? The police is trying to investigate the entire matters. Now from the, my lord, other is the real statement and peruse the statement of the other witnesses, my lord. The present petitioner of item number 23, he is the main supplier of all those contrabands to the my lord, other accused person from whose possessions, my lord, those contrabands, heroin and my lord, top syrup were recovered, my lord. So still now, my lord, in this case, investigation is going on. So what are other materials against the accused persons, my lord? Now, my lord, only, my lord, during at least, my lord, after some days, maybe some other witnesses, independent witnesses, police may collect.
That is not the law, my lord.
And at this point of time, in many cases, my lord, in this type of NDPS cases, my lord, what happened? Everywhere, my lord, police arrested, my lord, in case of, my lord, transporting by way of vehicles also, driver, helper, assistant of the helper, those persons were, and those persons were in many cases, my lord, were initially arrested. Thereafter, my lord, at that point of time, those contrabands were found in the possession of those persons. So, my lord, thereafter, my lord, during investigation, it is found that they are not only, although, my lord, they are involved in, my lord, my lord, selling or transporting all these material. Ultimately, my lord, who is the main supplier? Here, in these cases, my lord, during investigation by the police, it reveals that the present petitioners are the main suppliers. They are supplying, my lord, continuously, my lord, since long they are supplying huge amounts of contraband to these persons, my lord, and for which they are selling it to the, my lord, various, my lord, to the other persons, and thereby, my lord, these are offences against society, my lord.
My lord, the law is very
clear.
My lord, that, my lord, the moral thing is different, my lord. The law, principle of law is that till, my lord, 92 days has been gone, my lord. Till that there is no material, admittedly, my lord. So, they are putting me in the custody only on apprehension that tomorrow some more material will come. How long I will be in custody, my lord? Is it a law, my lord? On a basis of an anticipation, I will be in the custody. That's not the law, my lord. You cannot put me on an anticipation, my lord. The learned public prosecutor submitted that till that there is no material.
No, my lord.
Only that the co-accused statement. Apart from they are searching for the other material, tomorrow it may come. After all, tomorrow is another day, my lord. My liberty cannot be curtailed in such a manner, my lord, that on a basis of an apprehension that tomorrow some more material may come, on the basis of the co-accused statement, let him reply that on the basis of the co-accused material, he can be put in the custody, my lord. That's not the law, my lord. Lord, you kindly see the page 155 of the judgment, my lord. Paragraph, my lord. Page 141, my lord.
And my lord, one another accused, one Rafiq Khan, he is still absconding. He is one of the partner of the present accused
That
person.
cannot be the ground, my lord. The Supreme Court, my lord, in the Tufan Singh case said, my lord, this cannot be the... Only in a 438, my lord, there is a distinguish has been made, my lord. In case of a 438, yes, the co-accused statement may be relevant for the purpose of investigation, but not in a 439. The distinguish has been made by the Supreme Court categorically, my lord, the 439. So, I am entitled for bail if there is no material at all, as on date, my lord. 3 months has gone, my lord. Till then, there is no material. If I am supplying so much of, as per his statement, where is the material, my lord? Where from he has submitted all this material, my lord, that I have been supplying, so I am the kingpin. Where is that material, my lord? Where from he has come to not knowledge, my lord? Only the co-accused statement, which is not admissible.
My lord, during investigation...
That is the law, my lord. That is the law set by the Supreme Court, not by me, my lord. The Supreme Court has said that the 439, you cannot use it. You can only use it in a 438, my lord.
Your lordship may kindly peruse the case. There is some, not only the statement of the present accused person, 1 or 2 independent witnesses is also there, my lord. And regarding those, my lord, how they are, my lord, the name of the present petitioner is also there. Your lordship may kindly peruse, my lord. And my lord, the statement of the present accused person is also, my lord, available in the case diary. The last portion, your lordship may kindly.
My statement is how it is relevant of my confessional statement, my lord.
And today is, my lord, regarding the present petitioner, is, my lord, 90 days. My lord, here mandatory period is 180 days, my lord. Investigation is still going on.
Last 3 months there is no material apart from the court. As far as while the rejecting the bail order, my lord, that was on 15/6/24, my lord, the last order. Till then there is no material, my lord, as per the rejection order. Only the co-accused statement. And the forwarding report also said as per the co-accused statement, I have been implicated. I have been picked up from the court premises, my lord. And nothing was seized from me. Only that basis the order. My rejection was only on that basis, the co-accused statement. There is one judgment, my lord, with the copy, my lord, that only in 439, my lord, 438 it is applicable, my lord, the co-accused statement, not in 430. My junior will do it.
Otherwise, my lord, here in this case, my lord, mandatory period during police has time for 180 days for completing the investigation. Here today is 90 days. So still, my lord, there are times with the police to get further, my lord, materials if required, my lord, anything against the accused petitioners, my lord. And for which, my lord, in NDPS cases, my lord, mandatory period for, my lord, submitting searches 180 days is provided by the Act itself, my lord.
May I please, okay? My lord, I am for item number 22, my lord. My lord, in this case, my lord, as per my lord section, my lord, the contraband is, my lord, a commercial quantity. But my lord, as per seizure list, my lord, kindly see seizure list, my lord, page 13, my lord, next 2. I have annexed, my lord, seizure list. Last part, my lord, from my possession, my lord, 25.05 gram suspected brown sugar kept in 2 numbers of silver colored plastic top cases. This has been recovered, my lord. This is not, my lord, commercial quantity, my lord. This is lesser quantity, my lord. And my lord, now I am, my lord, under the judicial custody, my lord, 101 days, my lord. I have been arrested, my lord, on 14th April, my lord, 2024. So, my lord, this is not commercial quantity, my lord. This is, my lord, a lesser quantity. So, in case of commercial quantity, my lord, there is, my lord, 180 days, my lord. But in this case, my lord, not 180 days, my lord. This is my humble submission.
Those both the accused persons were arrested together in the residence of my lord the present petitioner, and thereafter my lord, on the basis of their statement, those my lord contrabands were recovered from various places from their estate. So both the accused persons were arrested by police together in the house of my lord Qasim Ali Parmani.
My lord, the contraband seized, my lord, this is not, my lord, commercial quantity, my lord. This aspect may be my lord, kindly considered, my lord. This is not commercial quantity. It is from the seizure list, my lord. It is not, it is from report, my lord. My lord, if it is not commercial quantity, my lord, I am entitled to bail, my lord. Oh, bless you.
Seat already. We don't just seat or CD required, but yes, it only matters one seat. Oh,
Not Mr. Lordship. Petition has behind about last 258 days, Lordship. And so far as response number 2 is, Lordship, I have
21 my lord search-sheeted case scan copy of LCR not yet issued.
Lordship, so far as response number 2 is concerned, Lordship, I have taken step long back, Lordship. But still, Lordship, are at 27, Lordship, kindly say acquisition dated 27, Lordship. Still, that steps has not been received by the registry, Lordship.
Where you have, I mean, filed your thing, is there any wrong procedure? Because
No, Lordship, no, Lordship. I have taken steps, Lordship.
No. Steps you have taken,
No,
but
Lordship.
steps have not received by the registry. Why?
Best known to the Lordship.
Now, what is the procedure? Through registry,
My lord, registry will provide to the office of the my lord, first they will have to submit before the registry.
yes.
Then my lord, my lord, from the registry to the office of the public prosecutor, and then we will send it to the my lord concerned officer in charge of the police station. And after my lord serving the copy, he will send the report to our office, my lord. To the my lord, some directly they can also send to the registry also. And if the registry will not get the my lord report, then we will get the instruction from the concerned officer in charge, so telephone or by any other.
but yes, but here steps are not been received by the registry.
Oh, then my lord, they have not submitted the.
I have submitted, Lordship. I have submitted this copy to the office of PP, Lordship. They assured me that they will.
Among directly no,
group কৈছিলে
নহয় registry
group কৈছিলে
then my lord,
But
he
he did
said
not-
that
I
he directly
submitted.
submitted to our office.
Lordship. I have submitted.
Procedure is to registry
Yes,
to go.
ma'am.
That's
Why
why
say
the office
they
knows
told me
the
that
registry.
they will serve the copy to the registry, Lordship. They have told me, Lordship.
How can we serve, my lord?
I have submitted.
Well,
the
I will
copy,
get the
Lordship.
instruction
They will
from
get
the concerned OC. In the meantime, I have to supply the DRI. My lord, in the meantime, I will get the instruction from the OC, my lord. Let him, my lord, follow the procedure and submit one copy to the registry, my lord.
Now, scan copy is also not received.
Not yet received, my lord.
258 days, Lordship. Kindly stop that 25th.
Demanding
258 days.
21.
258
Report. Submit report. Scan copy. But from the office note dated 27. Steps of strength of is not keep by how is from that about it that and with the that of the public record that and what about number the notice is up. Then the matter be according to yes, water both come.
My lord, on already 258, then my lord on 2nd of August, my lord. 2nd of August.
Take the instructions also, Mr. Waterford.
Yes, I will get the instruction, ma'am.
Obliged.
May I please your lordship, this is a 439 application. Petitioner is behind bar since 97 days. Lordship, FIR is on case 15.
My lord, certificate case, my lord. POSCO is also there, my lord.
Yes.
Here also LC I have received.
I have already submitted the charge sheet and the medical report. If you, lordship, would see... Notice I have already given. I have the receipt copy.
Here also, my lord, same problem.
Not taking steps.
আমার অফিসত দিছে ৰেজিষ্ট্ৰি দিয়া নাই
ৰেজিষ্ট্ৰি পৰা আপোনালোকৰ অফিচত পঠালে
here also my lord
lordship
Directly submitted the,
yes.
I mean, the state to the office of the deputy prosecutor.
Yes, lordship. I have the receipt copy.
here also my lord
Same problem.
here also my same problem, my lord.
Because as per the note of the registry, they have not received any steps on responsibility.
Lordship, I have the receipt copy.
In this case also I will get the instruction, my lord. Let him.
Copy from whom?
The office of the PP.
Our office has received this problem.
Lordship, already 97 days and he is just a 19-year-old boy.
Well, I will get the instructions.
Lordship, FSL is also negative and in the medical report also it is stated that no recent sexual activity is concerned here. So, Lordship, I may be granted bail. There is no material fact in the case.
See, obviously, this is the POXO method. One, we have to...
Lordship, interim may be granted in the meantime.
Step on.
Huh? Yunus Khan.
Here also,
Here also, my lord, I will get the instruction. In the meantime, my lord, he is directed to follow the procedure, submit a copy to the registry, my lord. Otherwise, I will get the instruction. In the meantime, already, if notice served, my lord, then my lord.
Lordship, a short date.
Here also, can be fixed.
On my lord, on same date, my lord, 2nd of August. তুমি এটা কাম কৰিবা কপি আনি দি ৰেজিষ্ট্ৰি দি দিবা ওর মধ্যে আমার অফিসে অফিসিয়ালি রিসিভ কৰিছে তাৰ ফটো তুমি এটা দিবা এটা মোক দি দিয়া মানে আমি অফিসত খবৰ কৰিম যে তোমাকে ৰিচিভ কৰিছিলোঁ তোমাৰ ওচৰত আছে নহয় কপি
এইটো বেলেগ হ'ল এইটো অফিচত ইনচাৰ্জত দিয়ক আৰু এইটো কি দিয়া
May I please, this is a 439 application, Lordship. And on last occasion, Lordship called for case diary and issued notice upon the respondent. And steps were taken, Lordship. Office note dated 15/7 shows that notice has gone, Lordship. Whether it is received or not, no endorsement is received back, Lordship. Case diary was also called for.
We have received the case diary.
Case diary received, ma'am.
2 months in custody, Lordship. The main accused, Lordship. We have for the other 2 persons, Lordship.
One steps so received by the office not passed.
itu নাজানো 15 তাৰিখে ইয়াৰ পৰা গৈছে আজি পিছকালি খুব প্ৰব্লেম মানে আমাৰ দুটা মেইন একটু বেলেগ
My lord, all these cases may kindly fix on 2nd of August. In all these 3 cases, I will get the instruction from the my lord concerned.
So you will retain the CD till next date of
CD is received, my lord. Otherwise, my lord, these are otherwise.
It will be retained.
Yes, my lord. Otherwise, my lord, there are some my lord, offense is serious, my lord, case of gang rape, my lord. There are materials also. So I will have to get the instruction from the.
We have already taken steps.
Yes, sir. It is already there.
Yes.
At पैसा में तो किलो ले लो
2nd of August?
Yes, ma'am. All these 3 cases.
May I please, Your Lordship? FRPS Lordship, 24 Lordship, others 2 accused already granted bail Lordship. They are arrested in the 27th May and the present petitioner were arrested on the 24th May Lordship. Considering the length of detention Lordship, the other 2 accused already bail Lordship.
In some of the cases, your lordship has asked for the injury report, for which case diary. Otherwise, in BA, your lordship has granted. Some your anticipatory bail, your lordship has not granted.
Regular bail.
And so CD sent back for updation along with injury report.
The lordship,
here the present accused person is in jail since
59 days.
Today is 59 days.
And the other 2 accused Lordship arrested on the 27th May Lordship, and the present petitioner were arrested on 24th May Lordship. The other 2 accused already granted bail. The public are gathering. The police has the registered against the case Lordship.
on the ground of faith.
Yes, yes.
Artist Anna, artist keyboard, that submitted by Tony from the TTM and
North Look,
North
North Look.
Okay, we're done.
Deputy.
That upward. No. And I put up drop it. Share of that.
Your Lordship. Today is 40 days she is behind the bar, Your Lordship. Another co-accused has been granted bail by Your Honor, by Your Lordship, considering the ground of arrest that, considering the ground that period of detention, Your Lordship. Another co-accused has been granted by Your Lordship, considering the period of detention, which is 33 days, Your Lordship, and I am behind the bar for last 40 days, Your Lordship.
That basically the other accused was penalty to ground for considering. What is your case?
My case, Your Lordship, she is behind the bar for last 40 days. She is a lady, Your Lordship, and a mother of a 1.5-year-old child. And apart from that, Your Lordship, the case is registered under Section 387, Your Lordship. Whereas there is no ingredients of 387, that is fear of grievous hurt and or death. It is a this case is there is a only fear of injury, Your Lordship, which is applicable in Section 383, Your Lordship, which is bailable, Your Lordship. There is no fear of death or grievous hurt, Your Lordship, and the main ingredients of Section 387 is fear of death and grievous injury, grievous hurt, Your Lordship. But as per FIR, which is at page 17, relevant page at page 20, Your Lordship, there is, they threaten me to harm my reputation and damage the reputation of my family members if I fail to pay the demanded amount of 3 lakhs. To harm the reputation only, Your Lordship. So Section 387 is not applicable in this case, Your Lordship. At best, Section 383 is applicable, which is putting person in fear of injury in order to commit extortion, Your Lordship, which is bailable, Your Lordship. But to make the offence is non-bailable, Your Lordship, this section has been added, Your Lordship. And I am a lady, Your Lordship. I am behind the bar for last 40 days, Your Lordship. I am a mother of a 1.5-year-old child, Your Lordship. And another co-accused, two co-accused has been released on bail, Your Lordship, by Your Lordship, considering his length of detention, which is 33 days only, Your Lordship.
Yes, what?
Well, only because she is a lady, my lord, that is not a ground for my lord obtaining bail, my lord, only because she is a lady for which my lord this type of offences committed by her. And my lord, from the security person of the my lord, that he is the tenant, my lord, Roslyn Ahmed, the present petitioner is the tenant of the my lord, that flat, my lord, Sandhya apartment. This is the statement of the security. He has stated, and other witnesses also there.
I am not Roslyn Ahmed, Your Lordship.
Roslyn Ahmed.
I am not Roslyn Ahmed, Your Lordship. I am
no,
item number 29, Your Lordship.
Yes, item number 29, my lord. He is also, my lord, she is also accomplice of my lord Roslyn Ahmed. Roslyn Ahmed, by using all these persons, my lord, my lord, created this group of my lord honey trapping, and thereafter, my lord, how your lordship has already earlier done for the case diary by luring those persons, my lord, later on, my lord, taking photographs, and thereafter, my lord, demanded money. And during that, my lord, police also, my lord, came to know that GDNP is also there regarding that some illegal activities is going on in that flat, my lord, apartment. And in the basis of that statement, police already searched and arrested all these accused persons. Everything is there in the earlier order passed by your lordship. And how these persons are involved in case of in all these cases of my lord honey trapping, and they are for demanding money, my lord, making photographs, and by wearing police dresses also, my lord, some of the persons. Already your lordship has considering the my lord, length of detention granted bail to some of the persons. Regarding that, your lordship may consider that is a different aspect. But regarding the my lord materials, these are the materials. They are all accomplices in a working in a my lord. They are a gang, my lord. They are racket, my lord, racket doing all these type of illegal activities. These are actually my lord offences against society, my lord. Otherwise, my lord, charity your lordship may consider or not, my lord, it is up to your lordship.
But it installed by Bureau of the problem with what if that down the what and what it also at the knowledge at Japan and also it was for it was arrested by one part of the all brand there are brand for and about okay, you are granted case.
Obliged, Your Lordship.
Yes, one.
Same date, my lord, arrest, my lord.
Date of arrest is same.
Same, all are same, my lord.
Your petitioner is, I think, she is the prime accused.
No, madam, I reside here, my lord. I am a divorcee, my lord.
Yes,
I-
that's why you are doing all this business.
No, I am in this for the last 7 years, madam. I am there.
Yes, yes.
Section
You are doing all this.
the 387, how it comes, madam. Only
Apart
question,
from 387, 100 clipping are there.
100 is there, madam. 387, how it comes. I am only on that, madam. It may come only 383, madam. 387 does not come at all, madam. And the person who impersonated, madam, they are getting paid. So, madam, I think, madam, because on the ground of parity, madam, because all are on the same footing, madam. Otherwise, madam. Otherwise, all of, if there is anything, my lord, all have done these things together, my lord. But so much, this lady for the last 7 years, she is living with her children, my lord. With one daughter, one son, grown up daughter, my lord. Her son is,
Should not do all these things.
no, that's too much. That will advise them, my lord, if there is anything, my lord. But further custody is not, my lord, my subject to my, it is not at all like that.
Yes.
You are assisted by
Yes, assisted.
Ayush.
Obliged to. CGM Kamrup Metro, madam.
CGM Kamrup Metro, 20,000 advance.
Obliged.
Certificate of CGM.
Wait, please, Lordship, in this case, the mandatory period, Lordship, tomorrow will be completed, Lordship. Lordship, here, case is that, Lordship. Complainant.
Otherwise, we have received the case ready here.
Yes, Lordship. Here the only thing is, Lordship, case is registered like in 365, Lordship. Section 365 is there. And victim has not yet been recovered.
Lordship, she was major, Lordship. So, I think my petitions, Lordship, I have
But
categorically.
even major has to be recovered.
Lordship, she was alone with his boyfriend, Lordship. And their Lordship.
Boyfriend?
Yes, Lord.
He is the boyfriend.
No. Lordship, here is the brother, Lordship, cousin brother. Here, Lordship, complainant as well as the present petition number 1 is the uncle and nephew, Lordship. And Lordship, what happened? That girl was alone with this boy. That was that thing has been supported by the present petition number 1, Lordship. So that's why, Lordship, that case was filed, Lordship. And the Lordship here, Lordship, the name is Sunil, who also our relative, Lordship. And 5 years ago, Lordship, the background this is the background, Lordship. Lordship, what has done by this police for the recovery of this girl, Lordship, I do not know, Lordship. And Lordship, moreover, Lordship, tomorrow, Lordship, the mandatory period will be completed, Lordship. Considering the detention period, Lordship, length of detention, Lordship.
Sharma, they both of they were arrested on
26/5.
Yes. The difficulty is, Lordship, all these petitioners are from Haryana, Lordship. And
from Haryana.
Yes.
Lordship, they are complaining, but also, Lordship, as because, Lordship, there are some people who are washing, Lordship, in local, our Assam, residing in the roadside, Lordship, for few days, there and there, Lordship. And
Banjara type.
yes, Banjar, yes, Lordship.
And if Lordship kindly comes to page 17, Lordship, bail rejection order. Here, Lordship, the gist of the whole case is there, Lordship. Page 17, Lordship, last paragraph. last paragraph. Prosecution case is that on 22/5/24, complainant Vijender Singh lodged and written a FIR stating that he, along with his wife, 2 sons and 2 daughters, while staying in a tent on the roadside of Morikolong MD Road on 22/5 at about 2:30 am, all were asleep under the tent. The accused person, Briju Singh, Subedar Singh, Gaurilal Singh, Vijendra Singh and Meera Singh, all came in a bolero and a small car and tried to kidnap informant's elder daughter, namely Jyoti Singh, 19 years. When the complainant and his relatives tried to rescue her, the accused person attacked them within Idle Road and ultimately kidnapped Jyoti Singh. The result of the case that reveals that victim Jyoti Singh has not yet been recovered. So that is the exact case, Lordship. Now, Lordship, 59 days, Lordship, but victim has not yet been recovered.
So, without the recovery of the girl, also it may not be possible on the part of the police to find that person. And from the city center, this recovery is not there.
Not there.
Lordship, in this case, present petitioner Lordship, they are also going to searching Lordship. Yes, because she, girl is the sister. They are also going to search Lordship, and they have a knowledge Lordship that she was alone with a boy's name is there. His mobile number also there Lordship. That police ought to have done something about the recovery. Moreover, I have.
You are on 30.
My name is
not reflected.
No, yes.
And they are not at all because they are all they are also developed started they are also victim and they are but the third was an item doctor was but however but as a friend therefore that the not get the for I not by that from then that the so that one that from the submission case of
Nagaon Lordship.
Naga. Okay, but then
Highly advised.
Wait, please, your lordship. The offence under 420 and 406, my lord. 53 days in custody, lordship. FIR is page 25. Land dispute, my lord, leading to the lodging of FIR. Arrested and in custody for 53 days, long days, my lord.
3 days.
53 days. Page 25 is the FIR, my lord. Long FIR, my lord. The allegation is, my lord, that I misled them into entering into an agreement. I paid them 1 lakh, my lord, and thereafter I demanded money from them, or 50% of the land. That is the whole allegation, my lord. Everything is documented, my lord. I am in custody for 53 days in this case, my lord. I don't know whether if your lordship completely read the FIR, but I don't think it is disclosed as a cognizable offence, my lord, or 420 or 406.
Yes, case they received, my lord. Other on the pretext of, my lord, providing protection of the land, my lord. Later on, they demanded 50% of the amount of the land, and also thereby they, in fact, my lord, trying to get the land of the petitioner. Otherwise, considering the length of detention, my lord, on the 53 days. Police has collected some of the documents, those agreements, but those documents are not part of the CD, my lord. Only but seizure list is available, but those documents are not available in the case diary.
But as part of that is those documents were already collected.
Yes, seizure list is available in the
That's
case
the
diary.
agreement and all these are
All those police has stated that in original police has seized all those documents from the present accused person, but those are not part of it. Considering the length of detention, otherwise materials against is there, because they are initially, my lord insisted to, my lord, protect the land of the. He is the informant is the, my lord, owner and possessor of the land, to protect the land from the, my lord, land grabbers. Later on, my lord, himself, my lord, tried to grab the land, demanding money, my lord. On these allegations.
that day Mr. Lal protected their
Lal.
to protect
Yes.
the lady. Oh, yes.
Lordship?
Case is of
Yes, is in
Kamrup
Kamrup.
Metro, Lord.
Kamrup Metro.
Okay, okay.
I am obliged.
Ask your petitioner to do more good things for the person.
Obliged.
May I please, Lordship? Lordship, in the last occasion, all for the President, my Lord.
Huh?
Case diary.
Case diary.
Yes, my Lord.
Petitioner is in interim, my lord. Case diary not received.
Case diary not received.
Yes.
Yes, what?
My lord, 27 8.
27.
8.
Your interim extended.
Bless my Lord.
It is CD is not received here, no?
No,
Interim may be continued.
yes, interim may be continued. On my lord, 27 8.
Okay, you enter.
Bishop.
Yes, sir. May it your Lordship. This is a case whether custodial integration is required or not required from the FIR, your Lordship. Page 8, madam. Guard is of 39 years, madam. As per FIR, she is 30 years. And boy is 21 years. Might have some relation. Yes.
Boy is 21 years.
21 years, madam.
Okay.
And there might have some relation, it may be there, madam. But the way you all kindly see whether section are attractive or not, madam. She's a widow, madam.
So who lost the FIR? Her father?
Yes, her father. Madam.
Yes, Mr.
Custodial.
Your opinion.
Kindly make it taken up at 2 your lordship. At 2 your lordship.
I will not be available, madam.
Your lordship.
Oh, yes, the subject. Why is that?
Because the lordship, the engagement with Jadalam, he's on legs in another police officer. And 2 your lordship.
Otherwise, Jadalam is appearing for the case.
Yes, yes.
Let it be, but I don't know.
My lord, I may have some problem. PP, to assist the PP, basically, they have to assist the PP, my lord. Or for some time, after 10 minutes, 15 minutes. Good hour, more some problem over me.
Yes, what to do?
My lord,
Have
PP,
some other work.
maybe, my lord.
She may not be in a position to say anything in that regard.
Only, my lord, on the face of it, whether custodial integration is required or not. Something may be there, but I am not, my lord, reviewing. Maybe there.
I just,
Yes.
I may agree with you with that regard.
Yes.
Yes, Sharma, and let her,
If I have showed that there is love affairs, father is saying.
Let them have their satisfaction also. Otherwise.
At 2.
At 2 will try, because that would 3-4 items are already been picked.
Only your lord.
If your senior may come within 10-15 minutes, no, not possible.
Anyway, my lord, my submission, if I am not there, my junior will be there, my lord. But it is a case.
Main submission is that custodial interrogation.
No, not at all. If I have shown that there is love affairs, my lord.
Okay, will not.
She is a widow, my lord. And 21 years old, my lord. Obliged to us.
Merely Lordship. With 430 reflection Lordships, AFIR is page 14 Lordship. Page 14 is the AFIR Lordship.
CD not received Lordship.
I kindly have a look at the AFIR Lordship. Whether 41 notices has been served to me Lordship. I could not appear due to some apprehension that my lord, some protection may be done. I will appear on Lordship before the police Lordship. Since 29/5, no interim is there Lordship. Today is the second date. CD has not been received, and that 2 Lordship, 2-3 dates Lordship, but matter has not been reached Lordship. I am not an, I am service holder Lordship.
Why 408 and 430 is there?
Yes, Lordship.
Lordship, page 14, Lordship.
Page 14 is the affair Lordship.
Last paragraph, Lordship.
Yes.
The last paragraph, second line. As per inquiry report, Rahul Datta, the then SS IC of ASTC Silchar 7, presently working as computer assistant at POV section headquarters is responsible for showing the excess issue of HSD for which is liable for punishment. An amount of 21,33,892 was paid by DDMA filter to so-and-so. Only the remaining unpaid amount of so-and-so may be recovered from him as the amount of so-and-so ordered for recovery is based on mathematical calculation. So, Lordship, there are some allegations, Lordship.
My lord, that amount has not been paid till that Lordships. That is still pending, Lordships. And I have issued the coupon as per my instruction of the driver and
What is your instructor? Why CD is not there?
Lordship, CD, we have sent communication, Lordship, on 3 occasions.
Yes.
It's from Kasar, Lordship, Praveen Desai. If Lordship kindly gives a short date, Lordship will produce. It's from Silchar, Lordship.
My lord, 41 has been charged to me, Lordships. I am ready to appear, Lordships. Because at that time I was a service holder and that amount has not been still in pending, Lordship. That has been a missed, Lordship, till that, Lordship. So, my lord, I am ready to cooperate, Lordship.
So, probability of your
Next week, okay.
Yes. Next week.
Next week, because
Yes, he is not in it. That's why
Lordship.
he is not in it.
I am a service holder, Lordship.
Any date as per Lordship convenience.
On Friday.
Friday.
Friday,
Friday.
no,
No,
next
not
week.
Friday. Next week. But Monday, 31. 31 to 20. Wednesday. 31, 70 to 20. 31.
Right.
And your you just communicate with the IO also because 4-5 days has already been
Lordship.
is not a reasonable.
Lordship.
Your Lordship. 430 application, Your Lordship, and the FI is at page number 8, Your Lordship. Start from 8, Your Lordship. The allegation is that, Your Lordship, total 5 numbers of cattle, Your Lordship, has been stolen, Your Lordship, and transported in 2 different vehicles, small vehicle, Your Lordship. Here, Your Lordship, 2 vehicles here. One is Kia Sonet, Your Lordship, and other one is Baleno, Your Lordship. I am the owner of the Baleno, Your Lordship. Here, Lordship, my name is not in the FIR. My only guilt is that, Your Lordship, I have rented my vehicle to some other person. That is my guilt, Your Lordship. Otherwise, I am not anyway involved in this case, Your Lordship.
So those cattle were carried one
The
in a
cattle
one
were carried in a Maruti Baleno.
Baleno and
And Kia Sonet, Your
Kia
Lordship.
Sonet.
how many cattle? That's what.
In the Baleno, 3 cows, and in the
3
Kia,
cows.
3 cows.
Oh boy.
And in the Kia Lordship, 2 cows. He is apparently the owner of the Baleno vehicle.
Baleno, Lordship. I have my
So
registration
can be
certificate.
considered because he was not present at that time.
So being the owner, do you have any
Yes.
knowledge regarding that your vehicle is used for carrying those cattle?
Lordship.
You don't have any. Are you do you have aware of about these things?
No, Lordship. I'm not aware of the fact that my vehicle has been used for storing some cattle or transportation of cattle, Your Lordship. After that, Your Lordship, I just got to know that, yes, my vehicle has been used for, and very sudden part is that, Your Lordship, my vehicle has already been destroyed, Your Lordship. It was not in a condition to recover, Your Lordship. It is in the FIR itself. Mari Bhani says, I am reading the line, Your
They were
Lordship.
caught by the villagers.
Yes, Your Lordship. It was caught by the
They were
villagers
trying
and
to
the vehicle has been...
run away, Lordship, and while they were trying to run away, Lordship, their vehicle met with an accident with another vehicle.
Lordship.
Then they caught up the vehicle owner, the driver and handyman, and all were beaten up. Vehicles were more or less damaged.
Yes. সম্পূর্ণকৈ ভাঙি চুৰমাৰ কৰে, Your Lordship. That is there in the FIR, Lordship.
Somehow involvement is there, Lordship. But
the present whether it was justified and the number of recovered from the fund. But or transport of that I thought that about it done by your clearance bill cleared in Kellogg, open with DIU, appeared for DIU 70 and open.
Deeply obliged, Your Worship. We will not receive, Your Worship.
40, 50.
Still not received.
Are you on it?
Earlier entry note is there.
If there be remind. Okay.
21.8.
21.8.
Earlier entry order may be continued, Your Worship.
Yes.
Matter.
Wait, please, Your Worship.
Yes.
My Lord, petition under section 438, my Lord. The FIR at page 11, my Lord. Here, my Lord, the petitioner before your Lordship is the owner of the vehicle, who is alleged to be beard Burmese beetleland. Here, my Lord, before reaching FIR, may I read annexure 4, my Lord, page 21. It is an agreement between the owner and the driver. The petitioner purchased the vehicle on loan and subsequently that vehicle was given on hire with the driver, executing a hire agreement on 9/1/2024 at the rate of 60,000 per month of rupees. Subsequently, the driver of the vehicle regularly used to pay the monthly rent. And subsequently, that vehicle was seized by the police of Hailakandi. And at that situation, the owner of the vehicle no way connected with the alleged offence as alleged in the FIR, which is registered under section 120B, 420, 397 and 411 IPC. In this case, my Lord, subsequently the vehicle was seized by the police and which was also directed by the Hailakandi judicial magistrate to release the vehicle to the owner. And when the owner of the vehicle was reached Hailakandi for taking the vehicle for with executing bond, then it is informed that the police of the said police station is searching the owner for arresting him. That is why his apprehension is in this petition. The Annexure 5, page 25 is the releasing order of the vehicle. Page 25, madam. Otherwise, if it is not released and if the owner of the vehicle is arrested, then the entire property will go and that vehicle also taken over by the financier, my lord. So, my humble submission before this honorable court, the pre-arrest bail may be allowed in favor of the petitioner who is the owner of the vehicle. In this case, CD was called for and CD, I think, received.
My lord, by creating secret chamber in that truck, my lord, 45, my lord, bags of 40 bags of, my lord, suparis were recovered from the truck, my lord, and those were transporting by creating secret chamber. Now, my lord, the Annex 1, my lord, agreement copy, by saying that, my lord, those, my lord, he provided the truck on hire to the driver of the vehicle, and he, my lord, by that way he gets an amount of rupees 50,000 per month from the driver. Then show any receipt that how you have received those amount of rupees 50,000 cash, or my lord, through your bank account. Produce that bank account that you from the driver you have received an amount of rupees 50,000 per month. Otherwise, my lord, from the my lord, that ground itself is not tenable if you fail to produce those my lord, bank account or my lord, money receipt of that receiving that amount of rupees 50,000. Otherwise, my lord, it is within the knowledge of the, my lord, the present petitioner, because in that truck, my lord.
My lord.
Yes, yes.
Because obviously, if it is just secret chambers are there.
Otherwise, my lord, let him appear before the my lord, IO, and my lord, till then he may be protected, and along with he may submit those documents by the bank that he received an amount of rupees, a proof of the bank documents that he received those amount from the driver of the my lord, vehicle.
And for that person, 8 per month, like travel. That is not a transport, quite or it is a transport, but it but as it not adapted as it the farm. That's what that from it that there were subsequent campus being where participant transport but the date of the tier 2 is from where can be seen that if this vehicle contract that I record other things. Okay, you can the interim protection appear before the IO.
My lord.
Appear before the IO with
My lord.
record your statement and then we call for the update.
Within 10 days, my lord.
10 days.
My lord. He is from Borpata and
Okay. And yes, update.
On my lord, 21/8.
obliged.
May I please, Your Lordship? Your Lordship, we were on interim protection, and the matter is with regards to the conduction of a gift coupon game. And CD
My lord,
was
in this
postponed.
case also, my lord, CD needs to be updated, my lord, because my lord, the notice there that my lord the present petitioner will have to provide some of the documents to the IO. Otherwise, my lord, after obtaining interim, my lord, he assured to cooperate with the investigation, but he has to provide some of the documents to the IO, my lord. So CD needs to be updated, my lord.
You want for it. You are prepared.
TL was for you.
The interim order dated 27.
And till now, his statement is also not recorded by the IO, my lord. Otherwise, he has only.
From it, you are saying that
The note of the IO is there. IO has stated that, my lord, while in charge of the present petitioner, while IO went there, then, my lord, he assured to cooperate with the investigation by only by showing the, my lord, a copy of the interim order. But he has not, my lord, visited the police station for recording his statement and providing those documents.
but from the note of charge then I provide some document showing the interim order of the period order according that updated is that the request and is that output but the change of capital put I and cooperative is not appear yes is not appear record it's not recorded but text you are on
Indeed, Your Lordship.
yes
On 29/8/24. And regarding there are two petitioners, my lord. Regarding the petitioner number 2, there is nothing in the case diary regarding his appearance before the IO.
let's put
Yes.
Petitioners. Much obliged.
Thank you. Motor not that. I can photo. But it's like here. Photo. Mr. Doctor, you are in which case?
My lord, item 11 and 12.
11 and 12?
Yes. It was for
It's an
admission.
admission matter.
Admission disposal.
Most probably admission will come up after at 2 or after 11 and 12. So yesterday the order was passed
The sentence hearing is today scheduled. Is scheduled today at 2 p.m.
at 2 p.m.
At 2 p.m.
Oh, then do
Probably
we
I won't be able to attend. The other prosecutors would be there.
other?
The other prosecutors would be there.
Oh, will be there.
Three of us are there in that.
Oh, yeah, here.
Pallab Kotak in Pankaj Patil.
Acha. Okay. Okay, that most probably it will be at 2 only.
made,
Yes.
you know. But it's a 482 application, my lord, under CRPC, my lord, challenging the FIR, my lord. Your lordship will find the FIR at page 10, my lord. Page 10, my lord. My lord, here, lordship will see the name of the accused, my lord. I am on behalf of number 2, my lord, Phul Babu Sheikh, my lord. My lord, may I read, my lord? Respectfully, it is stated that about more than 2 months back, my minor daughter, namely so-and-so, aged about 12 years, had visited the house of my father-in-law, namely Foizur Rahman, situated in so-and-so. Under such circumstances, the accused number 2 and 3, in a conspiracy, took my minor daughter to the house of the accused number 4, where she was handed over to the accused number 1. The accused number 1 had kissed my minor daughter on her face and different parts of her body forcefully without her will and tried to rape her, and on 24/07/23 also took photo snaps of the said incidents of my daughter and made them viral through every mobile. So, my lord, why I have come under 482, my lord? Because the case is registered under section 376AB, my lord. So there is a bar, my lord, under 438, my lord, of the CRPC, my lord, that I cannot come under 438, my lord. So that's why I have preferred this, my lord. And even if your lordship goes to see through the FIR, my lord, there is no role on my part, my lord. At best, my lord, if your lordship, my lord, one may say there is a conspiracy, my lord. If it is a conspiracy, my lord, it comes under, my lord, 361, my lord. And the punishment under 363 are bailable, my lord. Because the accused number 1 has done that bad thing, my lord. I am nowhere related, my lord, in this case. As because there is a bar under 438, my lord, under 376 AB, that's why, my lord, this petition has been preferred, my lord.
This notice may be issued, no?
CD can also
CD can also be
can there be some protection, my lord? No, because my role is nothing.
See, you are not supposed to file even 438 application. Just we have so protection be there. Anyway, we are trying to get the open state 2 weeks could be needed. I think.
Yes, my lord.
For issuance of notice 2 weeks, the minimum will be needed.
Yes.
डायरी करूँगा ना हाँ ये अंदर डायरी करूँ yes डायरी will be
CD on my lord 28
28 মানে 20
July
20
23 तारीख
July cannot be, it cannot reach by July.
12/8, my lord.
12. Can it be little bit, my lord, early, my lord?
No, after this to serve the notice in fact.
Yes, my lord. I will try to serve the copy to the officer in charge of the police station.
But the process is that it has to go to the registry, to the office of the public person. In that case, I don't know if it is come by 12. 12/8 is the date?
Yes.
Can I try, my lord, 9th of August? If possible, my lord, I'll take my chance, my lord.
Okay.
Because he is on the run, my lord, the person, my lord.
Okay. 9th of August?
9th of August, my lord. Because he is on the run, my lord.
Right.
May it please your lordship. Anticipatory bail application. The FIR is page 20. Basically, an issue of betting, lottery and betting. The prime accused is one Bijoy Soikia, page 20.
Prime accused is Bijoy Soikia.
Prime accused Bijoy Soikia, he has already been granted bail. Now, what has happened here? There was a raid again in this Haiti at the Bijoy Soikia's place, and therein, when this mobile phone was seen, in the mobile phone, the name of the present accused, the petitioner, was found, has been alleged. Now they have given 2 phone numbers there. May I just read the FIR? I have page 20. I have the honor to report that today on 23/3/2024 at 7:58 p.m. an information has been received at Duliajan police station via the above mentioned reference that one Sri Vikas Soikia Bhaiti of Duliajan Gogoi Market is running a nexus of illegal betting in cricket and Indian Premier League, engaging a lot of people. Accordingly, self by accompanying police official of Duliajan PS made an inquiry in this matter, and while visited his hotel located at Gogoi Market, Duliajan, he managed to escape the hotel and conceal somewhere after seeing the police team. He was searched in the market, and finally, at about 8:30 p.m., we saw him inside clothes store namely Soy's Home, located near Gogoi Market, Duliajan, wherein he was busy with his 2 mobile phones chatting with others. Meanwhile, Deputy SP Namrup sir arrived at the spot and took the stock of the situation. As we checked his 2 mobile phones, WhatsApp conversations with various customers regarding betting amount, was seen that it was found that the accused Bhaiti Adar Bijoy Soikia used the last digit code as betting number, and his customers engaged money against the last digit code, which is the last digit code of total score, and thereby collected money for his personal gain in the name of betting. In the WhatsApp conversation in his 2 mobile handset, it is found that the accused, with the help of his associate, namely Roshan Gupta, mobile number, these 2 mobile numbers, my argument is, the first mobile number does not belong to me, and the second mobile number is a mobile number of 9 digits. Therefore, it is not even a mobile number. It is based on these 2 mobile numbers only my connection is sought to be drawn in this FIR. Of Duliajan used some technology to create username and password against customers for online cricket betting through Lotus app and investment, various other apps like 22 Exchange, Radhe Exchange, Bet, etc. since long, which includes Women Premier League and other recent cricket leagues. And also the accused confessed that for each username and password, he had obtained rupees 2,000 from each customer to be delivered the amount to his partner Roshan Gupta, and has been running the nexus of illegal online betting. Many customers have lost money in the name of cricket betting, and the entire amount is obtained by Bijoy Soikia and his associate Roshan Gupta from his hotel. The accused Bijoy Soikia running the illegal betting business, which provoked the young generation to involve in invest in such illegal activities and disturbing the society by leading the youth in wrongful direction. His mobile handsets were seized, and as per seizure list for the possession of the accused Sri Bijoy Soikia. So this is the FIR. So in this particular case, your Lordship will see the person who was arrested and in whose hand the betting equipments and all these issues were there was Mr. Bijoy Soikia. Therein, the police is saying that in his mobile phone, they have found 2 mobile numbers, and they are linking these mobile numbers to the present petitioner. So my argument is that I am nowhere involved. The first mobile number is not registered in my name. So therefore, the police could not have said that I am linked with this case. And number 2, the second mobile number, Lordship will see this is a 9-digit number. A mobile number is always a 10-digit number. So the FIR itself, there is inherent inconsistency in the FIR itself. It says that these 2 mobile numbers are linked to the present petitioner. The second mobile number itself is not even a mobile number, and the first number is not registered in my name. I am completely not involved in this manner, in this particular case. And the sections that are involved, this is betting, 14 and 15 of the Assam Betting Act. Now these are otherwise 3 years punishment, but otherwise non-bailable. That is why I am before Lordships. So I am ready to cooperate in this matter. And another aspect is that I am a TB patient. Those papers are here. I have annexed all the papers here. And this Bijoy Das, this Bijoy Soikia, he has been granted bail. If I may just place that, Your Lordship. The prime accused has already been granted bail. And in another matter before this Honorable High Court, similar case, bail was granted, Your Lordship. Just for persuasive force, I am placing this. But otherwise, my case on merits would be, they are linking it with only 2 mobile numbers, and that mobile numbers, one is not even a mobile number and the other is not registered in my name. So therefore, there is no material as such for my custodial integration. Otherwise, I am ready to cooperate. I am ready to cooperate, I am ready to give my statement. But then they have never found anything in my possession. And this Bijoy Saikia is granted bail, Your Lordship. So I am praying for an interim protection, and I will appear before the concerned IO and give my statement, Your Lordship. And that will in fact help them in the investigation process to take it forward, Lordship. That is my submission.
Otherwise, my lord, now, my lord, while submitting, he stated that that is a 9-digit mobile number, but later on, Your Lordship, last portion, that was corrected. And that, my lord, that mobile number was, my lord, 10-digit mobile number, Roshan Gupta specifically mentioned from the last portion of the FIR.
So they have said this in the name and the
and
accused,
regarding, my
but
lord,
my case is it is not a registered number in my
now
name.
petitioner is, my lord, trying to shift the entire burden to Bijoy Saikia. My lord, he obtained the bail order is not with me, whether after perusing the case diary or not, my lord. And my lord, in this case, my lord, this type of offences are actually, my lord, offences against society. Life of many young youths were ruined by this, my lord, this type of illegal betting games, my lord. So my prayer before Your Lordship, at this stage, only, my lord, case diary may be called for, my lord.
So this was a FIR in the month of March. So till now, Lordship, the practical position is I am running, I am on the run. If interim protection is granted, I will definitely appear before the IO and the case can be taken forward, Lordship. In fact, it will help them in the investigation process. Therefore, my humble prayer, Lordship, before Lordship,
And Your Lordship, mobile
with strict
number
condition,
is also,
with
my
strict
lord.
condition to appear before the IO within 7 days' time, Lordship. And I am a TB patient, I have annexed all the documents here, Lordship. So considering these aspects, I am praying for interim protection, Lordship. And with the undertaking that I will cooperate, fully I will cooperate with the investigation, Lordship. And offence is otherwise 3 years, punishment is 3 years, but non-bailable.
It was but that's not the primary sector and provide mobile by first mobile number to the registered name. It's not registered name. Of 9. It's not registered for mobile. However, and done it or is the big not is the big of as so rare about that and the without principle is that faction is that expected. But it's submitted that the mobile number should be correct and it belongs to the okay, you will be under interim protection.
Lordship?
You will be under interim protection.
Yes, Your Lordship. Obliged, Lordship.
Appear before the IO with
Yes,
7
Lordship.
days.
On 19/8, my lord.
Obliged, Lordship.
মাঝে মাঝে আহো কেতিয়াবা কেতিয়াবা সদায় আহো নেকি মাঝে মাঝে